there's court everywhere today. Two Superior Court judges are sharing one courtroom. We've literally divided a space down in the ground floor in half, and the other state court judge is using that space for a ticket calendar. And then the former chief Superior Court judge using the other space. So I'm just going to stay in here today. Anyway, just a quick discussion about scheduling. So today is the 18th of June. Tomorrow's Juneteenth. The county's officially closed. On the 19th, Friday, the county is unofficially closed. I don't really know what to call it. It's a soft close. But our magistrate judge has elected to stay open, which means that court services has to come in, which means that my working plan is for us to start at 10 a.m. Friday morning, because I have my own commitment that'll get in the way there at a 9 o'clock start. As soon as the plaintiff's case finishes Friday, we'll do a little bit of housekeeping and adjourn and let the defense start Monday morning. Does that work for the plaintiff as a working plan?
Yes, Your Honor. And, we prefer, if possible, I think the defense consents in this, if we could come in a little bit late, maybe 10 o'clock.
Yeah, 10 o'clock is great. Because again, I'm the one with the conflict, so I'll tell the jury it's my conflict and that we're going to have to do a 10 o'clock start, and I'll take that. So
that sounds good.
Fine for defendant transcontinental.
Yep, fine.
Okay, well then that's our working plan, unless the county does something really crazy like decide to close. So I love my county, but sometimes they do stuff that makes me have to pivot quickly. So Alexander will keep an eye on that for us today. Okay, any other housekeeping before we bring the jury out?
No, Your Honor.
All right, y'all are going to play the deposition, the 30B6 deposition of Mr. Ogletree, is that correct?
Yes, Your Honor.
I forgot, how long is that video?
It's right about an hour and a half.
Okay. All right, what I'll do is I'll just tell the jurors that this video is an hour and a half. I would like to do it in one sitting, but if anybody's body doesn't agree with that, just raise your hand real high, get Clint's attention, we'll pause it, and then we'll take a quick break and then keep going. So yeah, that's our signal for need a break. Okay, if the jury is ready, then they come out. They're welcome to bring their coffee cups, notepads, whatever they need with them.
Better job at lunch.
All right, everybody's good. All right, so good morning. As always, thank you for coming back again. So where we're at, in fact, let me go ahead and give you all kind of where we're at and what the next couple of days look like, because we just got that all sorted out. So as far as today goes, we're going to continue with the plaintiff's case in chief. What we're about to do is the plaintiff's, I believe we're going to call a deposition witness. I've already given you the deposition charges on that. And you will keep those, and I'll give those to you again at the end of the trial. This witness testimony is about an hour, short of an hour and a half. I'd like to finish it in one sitting if that is possible. If anybody can't make that while we're playing it, just stick your hand up, get Clint's attention, and we'll take a break and let y'all step out. Or get my attention or anybody. And then as far as Friday goes, just so that you can plan ahead, Friday will be a shorter day. What we're going to do on Friday is we're going to start at 10. I have a conflict I can't get out of. So we're going to start at 10. We believe that we'll be in a spot where the plaintiff may be able to finish their case somewhere in the early afternoon, and then we'll adjourn for the day. That's the working plan. As you all are well aware, it will go where it goes, and we'll be as we be. And that's just the way it's going to go. But I just thought I'd at least give you that working plan since this is not a standard trial week for us. So, all right. So with that said, is plaintiff ready to call their next witness?
Yes, Your Honor.
All right. You may
Plaintiff
call.
is playing the 30B6 selections from Mr. Brandon Ogletree's 30B6 deposition on behalf of TCI.
All right. If I did my job right, no, I didn't do my job right. Hold on. All right. That should work now.
Please raise your right hand.
All right.
You solemnly swear or affirm your testimony today will be the truth, the whole truth, and nothing but the truth, self you got it.
Yes.
This will be the 30B6 deposition of Transcontinental Carriers Incorporated, taken by the agreement of counsel and pursuant to notice for the purposes of cross-examination and discovery and for all other purposes allowable under the provisions of the Georgia Civil Practice Act. Mr. Ogletree, my name is Annette Molina, and I represent Lewis Bennett in this case. And I'm going to be asking you questions about yourself, about Transcontinental, and the events of July 1st, 2020. I'm going to start by asking some background information. And if at any time I ask you a question that you...
All right. It's not coming out of the right speakers. Give me just, because y'all don't have any audio above you. Give me just 1 second. I want to hit 2 buttons and see if I can fix that. All right. Let's try that.
Is there a remote for this TV? I
So-
think it's this TV that's
Coming out of speakers of that TV as well.
Yeah, that's what I'm trying to figure out. So, and it's creating a very slight echo, and that's what I'm trying to head off. Let's just play it. I've got all the volume controls up here. I'll fiddle with them while it's going. And again, it's okay. It's just I want it to work exactly the way y'all want it to work. So, all right, if you'll hit play, I'll fiddle with the volumes. All right.
Can we approach?
Here, come on up. Yeah. I'm just gonna tell him I need it back. Yeah, I was about to say, that's fine. I'm happy to do that. All right, my coffee's kicking in. We're gonna take a break. I know I said y'all could take a break, but it'll be me. So we're gonna just take a same break as before. The other bathroom down the hall is available to everybody. So we're gonna take a quick break. I'm gonna let the party stretch their legs, use the restroom as well out this way. As soon as y'all knock and they tell me we're ready, we'll resume the deposition. Don't talk about the case or do any homework or get any information from anywhere you're not supposed to. I'll give you the formal version later. All right, thank you very much. All right. All right. Who do you all have lined up next?
Your Honor, before that, I would just like to submit a couple of exhibits that
Oh,
relate to that
yes.
deposition.
All right, this is the boring and important part we have to do in front of you, so just be patient with us for a second.
16 and 17. So handbook, load tickets, and pay stubs. Your Honor, so the plaintiff is submitting plaintiff's 15, which is pay stubs for Mr. Evans just before and just and following the collision or the incident.
All right, any objection to P15?
Not from Transcontinental.
No, you're
All right, P15 is tendered and admitted without objection.
Plaintiff's 16 is the load tickets from July 1st, 2020.
Objection?
No objection from Transcontinental.
no objection to the statements.
All right, 16 is tendered and admitted without objection.
And plaintiff's 17 is the Transcontinental Employee Handbook.
No objection from Transcontinental.
No objection from the state of Mr. Evans.
All right, 17 is tendered and admitted without objection. Anything else?
I think that's all this time.
All right, as far as your next witness, what's the time estimate?
It's a longer witness, Your Honor.
Okay, let's take a quick break and let me talk to them and get organized. And so while you're out of the, here we go. Members of the jury, while you're outside of this courtroom, do not talk about this case with anyone nor conduct any investigation about this case. You may only receive information from two sources, the testament evidence, which is testimony exhibits, the law, which I give you, and no other source. These attorneys and their parties have worked for years to be here. And if you violate these rules, this will create a devastating event in the trial. You may step back in the jury room at this time. Don't turn your phones on, just leave them off. We'll be back out here in just a minute. You may use the bathroom out in the hallway as well. All right. Just so that y'all are aware, my database where all your files is a place called Secure Share. It's a cloud option. They're currently under attack. It's called a VCR attack, which I just learned has nothing to do with the video cassette recorder that I thought it was. And so I currently do not have access to y'all's files. So just be patient with me. I have an emergency backup on my other computer, but it's back there. So tell me our next witness and what the layout is.
Your Honor, the next witness is Mike McCreary. He's a trucking expert for the
Oh.
plaintiff. I've never done a direct examination with him at a trial. So experts can talk a lot or they can talk a little.
Sure.
So I would imagine an hour, then.
This is a live witness.
45 minutes. Yes, Your Honor.
Okay.
Yeah.
Yeah, it's 11:08. So what we'll do is we will very likely. I mean, I hate breaking them up, but it seems like y'all. You know how like when you hit the first red light, you hit all the others because I keep
Yeah.
talking about. I don't want to break you up, but I keep breaking y'all up. So this is what we're probably going to do. So we'll go ahead and as soon as the jury's ready, we'll start. We'll finish with your direct. Even if we go a little bit over noon, as soon as you finish, we'll break for lunch, and then defense will do theirs after lunch.
Okay.
So, all right. Well, everybody where it is, except the restroom, and then as soon as everybody says go, we're ready. And just remember, I do not have access to your file at this moment. You call your next witness?
Your Honor, we are.
All right, and is defense ready?
Yes, Your Honor.
Yes, sir.
All right, so what we're going to do, sir, is we're going to do the plaintiff's direct with you first. Then I think we'll probably be right about at the lunch hour.
Yes, sir.
And so your testimony, despite our best efforts, will very likely be broken up over the lunch break. So I'm giving you instructions right now, and they already have these instructions, but over the lunch break, you're not to be reviewing your notes. You're not to be talking to folks about it. You're not to be in any way doing other than just as if he had asked his last question from the plaintiff and defense stood up and asked their first question.
Yes, sir.
Okay, all right, then we are ready for the jurors. So if they're ready, they may come on out. All right, everybody may be seated. Mr. Scholl, you may call your next witness, and you can swear your witness when you've done that.
Your Honor, the plaintiff calls Mike Napier to the stand. Yes, sir. All right, could you raise your right hand, please? You solemnly swear or affirm that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth, so help you God under penalty of perjury?
Absolutely, I do.
Could you please take a seat?
All right, and our mics are distant, so the closer you get, the louder it gets.
Yes, sir, and I'm usually not hard to hear, so.
Your Honor, before he begins, is there a way to kind of move that monitor, maybe, so it's a little more, no, not there, maybe to the side?
Yeah, let's do this. Hold on. Just be still. All right, we'll figure that out as we go. We're very adaptable here. Off we go.
Could you please state, are you ready, sir?
Yes, sir, I'm ready.
Could you please state your name for the record?
Michael Kennard, spelling Kennard, Napier, Napier, Senior.
And what is your profession, sir?
I provide analysis, consulting, and when necessary, expert testimony in the area of trucking litigation cases.
Have you been retained by the plaintiff to give opinions in this case?
I have.
Now, before we talk about your opinions, let's talk about how you came to know what you know about the trucking industry and trucking safety. Could you please describe your professional background and your work experience, which provides a foundation for your expertise?
Yes, sir. I spent 20 years in the United States Marine Corps as what we call a military occupational specialty of 0491, which was a logistician. I became, in the military, an expert in the movement of beans, bullets, bandages, and personnel, both in domestically and in foreign environments. I parlayed that training that I received while in the military to the private sector, where I started a trucking company called AA Quality Transport, and I sold that company and then went to work for another trucking company where I was the senior vice president of safety and compliance and corporate administration, as well as risk management. We sold those companies to the Florida East Coast Railroad, and then upon completion of my obligation with them, I came to Macon, Georgia, and started two more trucking companies, one called Semper Fi and one called Semper Fi Logistics, Inc. And one was a property brokerage logistics company, one was a trucking company. While doing that, I had been networked with a bunch of attorneys over the course of time, and one would call and another would call, and one thing led to another, and I started giving advice to lawyers as it relates to the standards of care in the industry. And then it ran into eventually doing expert testimony. So that is my work history leading up to me today.
Okay. Is that a Marine pin on your lapel?
Yes, sir. It's a retirement pin. Yes, sir.
Semper Fi.
Thank you.
Do you have a CDL?
I do hold a CDL. It's not active because I don't maintain my medical certificate, but I hold a CDL, and at any time I can activate it by getting a medical certificate. But I've held one since 1992.
Okay. And have you held it continuously since 1992?
I have.
All right. Tell the jury about your commercial driving experience, please.
My commercial driving experience is fairly limited as it relates to over-the-road trucking driver. An over-the-road driver would drive about 100,000 to 120,000 miles a year. I probably have 250,000 miles of over-the-road experience and another 100,000 in various other types of commercial vehicles like straight trucks. But that's just a part of my experience. I certainly have experience managing trucking companies and the education with that. But yes, I have a CDL, and I still participate in the industry. I provide for the Macon Food Center. I provide road tests to their drivers, and so I'm in a truck frequently.
Thank you, sir. I'm going to hand you. I'm going to hand you what we marked as Plaintiff's Exhibit 34. And represent to you that this is a CV you provided. My approach the witness.
Yes, and just to say it out loud, all of you may always approach the witness as you need to without asking for future permission. Y'all have earned it.
Thank you.
Your Honor, I'm going to object to the admission of it. It's continuing testimony.
We will address continuing testimony after the close of evidence. So I'm going to admit it, and then we'll discuss continuing testimony before anything goes out with the jury. So it's admitted over defense objection.
Thank you, Judge. Appreciate that. Mr. Napier, have you had a chance to review Exhibit 34?
Yes, sir.
And is that your CV that you submitted to us?
It is, yes, sir.
Okay. Your Honor, may we publish the CV to the jury?
You may.
All right. Mr. Napier, does your CV accurately reflect your professional experience and training in the commercial trucking industry?
It does reflect accurately my experience in training, with the exception of additional training that may not be on there.
Okay. Now, did you attend college, sir?
I didn't hear you.
Did you go to a university?
Yes.
And where did you go?
I went to the University of National University in San Diego, where I completed 3 years of college education and got an associate's degree in applied sciences, cum laude at that university.
All right. In addition to your attendance at National University, can you describe any other formal education and training you've received?
Yes. So throughout my military career, I received specific training in Title 49 of the Code of Federal Regulations for transportation. That is the code of regulations that provides the regulatory standards for all modes of transportation: air, sea, rail, trucking. And of course, while in the military, I was involved in all of those. And so I had been to various classes and courses from the West Coast to the East Coast, all with the logistical management and the training in Title 49. Now, Title 49 may mostly not have any application to the military. So why would I be trained in that? I'm trained in that because we use civilians to haul our stuff. We don't have enough lift capability to get our stuff to the airport, to the beaches. We use civilians to get our stuff. So we have to know what their rules are in order to use those private sectors. So that was the reason for that training. And so, and then after leaving the Marine Corps, I've had a host of other classes and training and driver training. I've attended what's called the National, we call it NATME, the North American Transportation Management Institute. It's an agency that provides accredited education to the trucking industry for certification of fleet manager and safety and compliance directors, a certified safety director. I didn't obtain this certification, but I did get all of the education for that course and the course prerequisites.
Thank you, sir. Are you familiar with the standards of care in the field of commercial trucking and in particular the safety standards?
Yes, I'm not just familiar, I'm hold myself as an expert in those areas.
And have you trained other carriers and drivers about all aspects of trucking safety?
I have.
Can you tell us about that?
Sure. It represents about 2% of my existing business. It's not overwhelming, but I like to stay involved in the industry. We provide consultation to a number of motor carriers in the Macon, Georgia area. We provide consulting to the Macon Food Bank, as I mentioned earlier. We provide, I sit on the Central Georgia Technical College's board, their advisory board for the commercial driver's license program that they have. I was invited and was on the Mott Miller advisory panel for their CDL program. And so that would be pretty much it.
Thank you, sir. Do you belong to any trucking industry groups? Trucking industry groups?
Yes, I belong to the Georgia Trucking Association, its Safety Council, the North American Transportation Management Institute.
Okay. And looking at your CV, I see that there's some lectures and that you've done and some, looks like some lectures and says instruction. Anything else you'd like to add besides what you've already gone over?
No, sir. I have provided those seminars many years ago. They're listed on there. I technically, not this time, don't hold myself out to do that very often because my book is solid and I just can't take any more calls. So we don't do those right now.
Your Honor, we tender Mr. Napier as an expert in the field of regulatory and industry standards of care in the commercial motor vehicle operations and safety field.
All right, Vince, any objection?
No objection, Your Honor.
Any objection?
No objection, Your
I
Honor.
will allow the testimony.
Mr. Napier, what's your firm's name?
TruckingExpert.com, Inc.
And do you work for plaintiffs and defendants?
I do. It's weighted about 65% on the side of the plaintiffs and 35% obviously on the side of defense. I appear at trial pretty close to the 65-35 percentage, but now my deposition testimony is far outweighted on the side of plaintiffs. So mostly I'm doing consulting work on the side of the defense, and ultimately end up testifying way more on plaintiff side than I do. But I would tell you, I don't hold myself out that one side or the other. Anybody that knows me would tell you that.
In your business, what determines if you work for the plaintiff or defendant?
The facts. If oftentimes lawyers have their own perspective, so we do an intake call. And when I get an intake call, they say, my client's done nothing wrong, and you need to tell us what the standards of care were for a trucking company. Well, I get into it sometimes, and I find out, well, I don't think I can help you. And so but what the facts say is whether or not I'm sitting in this chair testifying on behalf of somebody.
Do you direct your business through advertising or whatever to one side or the other?
Well, no, I do not. Obviously, I do have a website, and no, there is no, I don't hold myself out to one side or the other. And I tell every client that I have that these are my opinions and are not going to be the lawyer's opinions.
When was your firm first retained in this matter?
That's a good question. Let's see. I believe it was August of 2021.
All right, and is your firm paid for its work?
Yes.
Can you tell the jury what your firm charges for its work and what it charges for its work in this matter, including your appearance here today?
Yes. Up to the point of, I'm not sure that I have this added up correctly, but I have been paid or invoiced about $27,000 up to the point till today. And then my appearance fee here today is $3,500 for an appearance plus the time taken to prepare for the case. That money is paid to my company, and you should know that I have an office building. I got 10 employees. I got all the expenses of that. So this money doesn't just go to Mike Napier. I get a good percentage of it, but I don't make all the money. So, but the long and short of it is that, there's more billing to be done on this case as it relates to my preparation for this trial and my appearance today. And I think it's been paid, but I don't remember.
Okay. And do you mentioned that you have a staff that, and does that amount cover all your overhead? Or-
Yes,
Okay.
yes, that's inclusive of what the company makes.
And can you generally explain what you do to the jury on your day-to-day work on the cases and as part of that profession?
Sure, you're talking about like on a specific case or
Yeah.
what do I?
Just
So
generally what you do.
on a specific case, we get anywhere from 1,000 to 10,000 documents of what's called discovery. And it comes in the form of deposition transcripts, crash reports, accident reconstruction reports, human factor reports, all of the other experts that are involved in it, all of that comes to us, and I review every bit of it. And then in my review of it, I then take notes, and I call it that my abstract notes, and that helps me to remember what I read. I've got a document that I can look at to study from and not pull every document out. And so I do that, and my staff types it up, and they manage the documents for me and things of that nature. And then once I get all of the information, then I formulate my official opinions. Now, during this process, I have had to tell a lawyer what I anticipate talking about with regards to the industry standards of care, the regulatory standards, and what I intend to testify to generally so that they can disclose me to the other side. And so they do that before I'm even finished with the review of all the material. And so once I complete my review of the material, then typically I would talk to my client, have a meeting with them, and they would then set a deposition. And so the deposition would take place, and they asked me a bunch of questions, and I feel like I get beat up in it, but you get a whole lot of questions asked, and you answer all the questions, and then now the other side knows exactly what my opinions are. And so then, if it goes to trial, then I use the same study materials that I used for my deposition here at trial to teach you what the standards are and what my conclusions are.
Thanks, sir. Did you do that same sort of methodology when reviewing this case?
Yes, sir.
Okay. And can you talk about what the materials were that you looked at? I know I got your page here from that.
Yes, sir. If you,
Sure. Your Honor, can I need to utilize the element.
Oh, yes, we turned it on over there. And it should be lined in so that y'all can grab it. If not, I can hit the button and move it over.
Okay, can we show it on the screen, please?
You need me to do it, sir? No problem. And it'll zoom in.
Zoom.
Just remember the zoom button there is like the keyboard, so like if you push the button, it'll pause and then run away. So,
Can I hit it several times?
yes. It's a learned skill.
Yeah. Everyone see that?
No. All right. No, we're missing it on that TV.
It's not gonna be on that one.
It's not gonna be up there. Okay, well then I guess we need to keep zooming. All right, everybody thumbs up, jury? All right, I'm getting thumbs up across the board.
Mr. Napier, can you see the document?
yes,
Okay. And could you describe what that document says and what it is?
this is a typical document prepared by my firm for what a case file would look like. And every binder has a tab. So you got 1 through 28, I think, here. And in that tab, you could have several hundred pages of documents as I've outlined what they are in the description block of the table of contents. And so this is, the first 3 portions of the tab, I have produced to the other side as a part of my file because they wouldn't have it. It's my retainer agreement, those abstract notes I told you that I prepare, and any correspondence between me and the plaintiff, the retaining firm, the plaintiff's firm. And then everything else are things that they have provided me through the normal course of discovery, to the best of my knowledge, and that's a part of my investigation to review this information. And so I would have in here Mr. Evans' response to interrogatories and requests for production, Transcontinental, their first request for admissions, their ROGs, their RPDs, a letter that's trying to coordinate getting additional discovery. There's all of these pleading and responses that are listed. Then there's certain personnel documents on Mr. Evans and a medical card, the Transcontinental Carriers Employee Handbook, the vehicle inspections, load tickets. There's 3 medical examination reports that are involved in this case that have been produced or have been obtained. Then there's a deposition testimony of Mr. Ogletree, plaintiff's exhibits to those depositions, I believe, and Evans has someone has run a lifetime MVR on Mr. Evans, and the registration for the 2000 Mac that was involved in the incident, and the scene photos, and then of course Evans' records from a clinic. And so all of those things I have reviewed and taken notes on, and for the most part have testified regarding my opinion during a deposition.
Thanks, sir. You did review the accident report in this case?
Yes.
All right, and you saw pictures of the truck that Mr. Bennett was driving?
Yes.
Okay. And did the accident report show the owner of the vehicle to be U.S. Express?
Yes.
Okay. And was the name U.S. Express on the side of Mr. Bennett's vehicle?
It was on the side of the trailer. So this is a common issue in the industry. U.S. Express at one point in time owned the trailer, and it had been de-identified. You know, the stickers that they have on there that says what the name of the company is. Well, usually when they sell their trailers, they de-identify it, they strip that off. Well, it leaves a outline of what was there before. The sun does, or the sticky stuff does, and everybody's probably seen it before. And so when it was reported, they thought it was a U.S. Express truck, but it was not a U.S. Express truck. It was registered to Transcontinental.
Mr. Napier, probably the members of the jury and all of us drove here in cars today,
Yes, sir.
not commercial vehicles. Could you please explain how driving a commercial vehicle is different from driving a car, and what are the big things and nuances for that?
Well, let me first tell you that I don't think that any of us would want to get in a tractor trailer that hadn't been shown how to drive it. Okay, it's can weigh up to 80,000 pounds in weight. It's some 65 to 70 feet in length. It's articulating in nature, so it articulates on a fifth wheel. When you hit the brakes, they don't actuate right away. It's air brakes, so it takes another half a second for even the air brakes to actuate. The vehicle stops a lot different than your car does. You probably have gone through a yellow light sometime in your past in a car and done it safely. Odds are if you try to do it in a tractor trailer, you're not going to do it safely. And so it doesn't accelerate as fast. It doesn't move as fast. It's not as maneuverable. It's can have numerous blind spots depending on how you're sitting. It's got 7 mirrors on it, upwards of 23 or 27 different gauges. It is a massive vehicle. And so there are some standards that you might apply in driving a car, but the standard is different in a truck. So for example, we would tell you in a car, you got to look where you're going, okay, and look out for the other guy. But it's different in a truck. You have to look 12 seconds to 15 seconds ahead because you're up so high and you can see a quarter mile ahead. You've got to be able to anticipate the actions of others. You have to look for your blind spots. You have to look in the rear. And you have to do all of this while you work a 14-hour day. You're going to drive upwards of 11 hours and work a 14-hour day. So you have to be diligent in those skill sets to drive a tractor trailer. And so and in addition to that, this is a regulated industry, regulated by the Department of Transportation for the issues of safety. And it has specific rules that a truck driver has to follow. And this is my teacher's manual of the Federal Motor Carrier Safety Regulations. And these regulations, in order to operate a truck, requires a special licensor. You've got to have a special license, a CDL, and in this case, a Class A CDL to drive this truck. And you have to be knowledgeable of the regulatory standards to be in compliance with them. Not only does the driver have to know these things, but the employer is mandated to know these rules. And so that's the difference between, generally speaking, the standards of care that are applicable to a commercial driver versus one that drives a car.
And why are those FMCSRs important for a commercial truck vis-a-vis a passenger vehicle, a car?
Well, the mission of the Federal Motor Carrier Safety Administration is to reduce accidents, reduce injuries, eliminate fatalities. That's their mission. They want to do that. And so in promulgating these rules, in concert with the techniques provided for compliance and the techniques for safety, these regulations save lives. It dictates motor carriers should do things, and if they don't do things, their accidents will increase. That if they that their failures to follow rules, it can cause accidents. The failures to a driver to follow rules can cause accidents and injuries. And so, but for this regulatory standard, it would be like the cowboys in the West. I mean, we wouldn't have these regulations to hold them accountable for compliance. And the FMCSA tries to audit them, but only there's like 87% of all companies have never been audited. They don't have enough people. So they have to catch them on the road. They got to catch them at roadside inspections and at scale houses and things of that nature. And so, so this is why it's important to have the regulations, is for ensuring the accountability of both the owners of trucking companies and their drivers.
Are carriers required to know, understand, and follow the FMCSRs?
Yes. Matter of fact, the regulations say with specificity, and I don't like to quote numbers to you because you probably won't retain it, but under 390 of the regulations, it says that every driver and every employee shall be instructed to the rules of these regulations. Doesn't say sometimes, doesn't say not small companies, not big companies. It says every employee is supposed to be instructed on these regulations for compliance. And under 392, it requires the driver to get specific instructions on the operation of the commercial motor vehicle. And again, they're also required to get certain training as to obtain a commercial driver's license. And so, yes, there are a number of citations for providing instruction and training.
So drivers and carriers are both supposed to know and follow the FMCSRs?
Yes.
Is ignorance of the law an excuse for, or ignorance of the regs an excuse for either the carrier or the driver?
I've been taught that it isn't, that the FMCSA holds you accountable one way or the other. If you say you don't know, it's not going to be just, well, okay, go do it next time. You're going to be held accountable for that violation if there's one found.
Did you look at the deposition of the corporate representative from Transcontinental?
Yes, sir, I did.
On page 239 and 240, do you recall him saying that he did not know the rules governing drivers with diabetes?
I don't remember the page number, but I remember the testimony.
Is that consistent with the FMCSRs in your opinion?
No.
Now, you mentioned that the regs are the minimum standards. What does that mean?
So there are U.S. citation codes that dictate to us that these regulations are just minimum standards of care. The regulations even allow for the industry and for motor carriers to employ more stringent standards. And the industry, in fact, does do more stringent standards. There are a number of rules that are not codified or cited in the regulations that are put into effect for safety. I'll give you some examples. One thing that we get audited on is our management controls and systems for safety. Nowhere in the regulations does it tell you what are management controls and systems. It's layperson understanding of what management controls and systems. How do I document my qual file? Have I supervised putting together the qualification package? Did I supervise the application process? Have we properly vetted the driving employee to make sure that they're a safe driver? Have we vetted their physical examination to see if they are physically qualified? Have we done those things that are reasonable in hiring a commercial driver to drive on the roadway? This is not driving a car again. Remember, this guy has got to have a considerable amount of training and skill to drive these vehicles and know an awful lot about this book. They have to know this. And so, that's one example. Another one would be, let's say you're driving down the roadway and you have it raining. Well, a tractor trailer, and you're going to see that a lot of them don't do it. You'll probably remember this for the rest of your life. A tractor trailer should reduce their speed by up to 1/3 of the posted speed limit when it's raining. So if he's on a 70-mile-an-hour roadway, he's probably supposed to be doing 50 miles an hour. And why is that? Because he can't maintain the same control as you can with a car. Okay, that truck doesn't stop on a dime. And if an 80,000-pound truck hits you at 70 miles an hour, it's going to do some major damage to your life or injuries. And so they're supposed to do that. But that's an industry standard that we teach in a CDL manual to teach you how to operate the truck. And so I think that gives you some examples of your question.
Thank you, sir. Are you going to interpret the FMCSRs for the jury?
Absolutely will not. That's this man's job right here. The judge will tell you whether or not it's a violation of law. Now, what I will do is I'll tell you how, so long as the judge allows me, I will tell you that the content of the regulations, how does the industry treat that content for compliance purposes, but I'm not going to tell you they violated the law. I'm going to say they violated the industry standards of care, which includes the industry's understanding of that content. But only the judge can tell you it's a violation of the law.
Who are the industry standards of care applicable to?
Industry standards of care are applicable to the employer motor carrier as well as the employee driver.
How are licenses different for drivers of tractor trailers than drivers of cars?
As I mentioned, it will say on his driver's license that he has a commercial driver's license. It will say he has a Class A license. Whether or not he has special endorsements like for hazardous materials or whether he has a tanker endorsement is outlined on the license, but it is a special license. It's not the same as your driver's. It looks the same until you read it.
You talked about that the safety standards are applicable to drivers and carriers. How do the safety standards relate to the operation of a commercial motor vehicle?
Well, cumulatively, you have to take the compliance efforts of the content of the regulations, and that would be our methodologies for compliance and how the techniques for safety are employed in any given circumstance. So give me the circumstance and I can give you the standard of care. But the standard of care is a broad term, is that there's no one book. I can't get one book and give you all the standards of care. But if you give me a circumstance, I can give you a reference for that circumstance on how we train drivers to drive and how we teach supervisors and employers to act.
Mr. Napier, I understand that you drafted a document prior to your deposition that summarizes some of your findings in this case. Can you describe that, please?
Yes. So in every case that I'm not required to write a report, I craft what's called my talking points for testifying. These are just my notes, okay? And you'll see me, I'll refer to it a lot as I'm testifying today. And it's about a 14-page document, and it double-spaced, and it has all my opinions in a rough form for me to testify. I've had a lot of cases, and I want to make sure that I remember the facts correctly, and that I'm including everything that I intended to tell you. And so it's all in this talking point. Included with my talking points, though, I do what's called endnotes, like a footnote, okay? Except it's a separate pages of document where I cite certain references to show you and to show the court that it's just not me saying these things. Here are industry references and publications that say the things that I'm telling you today. And I don't think that there'll be anything that I tell you today that I can't show you a reference that I'm correct.
Now, after your investigation, I understand you reached a number of conclusions regarding the applicability of safety standards and whether or not those standards were breached by the driver in this case.
Yes, sir.
Can you describe to the jury the methods you used in formulating your conclusions?
Yes. There is a routine investigative process employed by the commercial motor vehicle industry, by trucking companies in general, okay? And that's called a preventability analysis process. It includes the investigation of an accident. And all they are attempting to do in the industry is to figure out whether or not the driver did those things that are expected of him that would have avoided the accident that occurred. And if he didn't do those things that are expected of him, then it would be a preventable occurrence. Now, we have a fancy definition in 2 places in the regulations. I could read it to you, but that's basically what it says. Now, if it's preventable on the part of the driver, and only if it's preventable on the part of the driver, then you're supposed to look at the operations of the motor carrier. Did the motor carrier do those things that are reasonable and in accordance with the industry standards of care for safety before they entrusted the person with that truck to drive that truck, or whether or not they violated any rules that led to his poor performance? And so that's the methodology for doing the investigation. And so it's a preventability analysis, and that's where my conclusions lead to.
Can you define what countermeasures are and how those apply to your analysis?
Sure, it's a part of that investigation. A motor carrier would figure out what they did wrong. So, for example, if you had an accident and the driver didn't drive his truck the correct way, it was a preventable accident, and what can we do to train that driver and or other drivers to avoid that accident so we can prevent the next occurrence? And so the FMCSA publishes what's called a preventability and countermeasure manual as a recommendation, a freebie. It's online for free, as a recommendation on what you can do to solve that kind of an accident history going forward. And so after we've deemed an accident preventable, we would execute countermeasures to prevent the next occurrence.
All right. When you evaluated this case for safety failures or countermeasures, did you look at the evidence and evaluate both drivers?
Yes.
Were you able to reach any conclusions as to the preventability or non-preventability of this occurrence?
Yes.
With respect to Mr. Bennett, what was your conclusion and why?
With respect to Mr. Bennett, that there's been no evidence provided that Mr. Bennett did anything outside of the reasonable standards of care while driving his truck. There's been no evidence provided of speeding, or no evidence provided there was something wrong with his truck. There was no evidence that he wasn't qualified. No evidence at all that he did anything that would have prevented this occurrence. So as far as Mr. Bennett was concerned, I found him to be involved in a non-preventable occurrence. There's no evidence at all to say that he did anything wrong.
Now, with respect to Transcontinental and Mr. Evans, were you able to draw conclusions about the preventability of this incident with respect to those parties?
Yes.
All right. Was it preventable with respect to Mr. Evans and Transcontinental?
Yes, sir.
Let's start with your evaluation of Mr. Evans. Regarding Mr. Evans, can you explain to the jury your findings and your conclusions one at a time?
So first, the first issue is to point out is that the CMV drivers are provided with specialized training. They're supposed to be specially trained to understand, to cover the importance of identifying symptoms of illness, fatigue, and other impairment issues. They're supposed to be able to identify. and know that because, why? Because they're dictated that if they're ill and or fatigued, they're immediately to either not get in the truck, or if it occurs while they're in the truck and they have time to do so, is to get off the road. So those are the regulatory standards. And because those standards were not adhered to by Mr. Evans, this was a preventable collision on the part of Mr. Evans because he was ill at the time he was driving and did not get off the road. So that was the first thing, and that's that is specifically cited by 392.3 of the regulations that you're supposed to cease operations if you're ill and or fatigued. So that,
Your Honor, may I approach?
Yes.